Hello everyone, welcome to the US Immigration News. As soon as Donald Trump won the election in November 2024, it was expected that the United States immigration system would not be the same. Now we are at the end of June 2025 and the US has entered into a new era with new citizenship laws. For generations, being born on US soil meant you were automatically an American citizen. It didn't matter who your parents were. It didn't matter how they got here. But in June 2025, after decades of debate, legal battles, and political promises, the Supreme Court cleared the way for President Donald Trump's executive order to fundamentally restrict birthright citizenship, a change with sweeping consequences for families, communities, and the nation's identity. In this video, we will understand how this happened, what the order actually says, who it affects, and why this could be one of the most consequential changes to U.S. immigration and constitutional law in modern history. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. When Donald Trump returned to the White House in January 2025, he wasted no time reviving a central promise from his earlier campaigns, ending automatic citizenship for children born in the U.S. to parents who are neither citizens nor permanent residents. On his first day back in office, Trump signed the executive order titled Protecting the Meaning and Value of American Citizenship. This order sought to reinterpret the 14th Amendment, which for over 150 years had been understood to grant citizenship to nearly all children born on U.S. soil, regardless of their parents' status. Trump's move was not without precedent. He had floated the idea during his previous term, but this time the executive order was immediate and sweeping. It declared that, effective 30 days from January 20th, 2025, only children with at least one U.S. citizen or lawful permanent resident parent would receive automatic citizenship at birth. The executive order, which took effect on February 19, 2025, introduced a new reality for families across the country. From that day forward, the circumstances of a child's birth in the United States no longer guaranteed citizenship. Only those born to at least one parent who is a U.S. citizen or a lawful permanent resident would be recognized as citizens at birth. The order also specifically included children of non-immigrant visa holders, such as students, temporary workers, and tourists, regardless of whether the parents were lawfully present. Federal agencies were instructed to stop issuing citizenship documents, including passports and social security cards, to children who did not meet the new criteria. Hospitals and state agencies were required to verify parental status at birth, creating a wave of administrative confusion and concern for families. The order was immediately met with fierce legal opposition. Civil rights groups and a coalition of states filed lawsuits, arguing the order was unconstitutional and would create chaos for families and government agencies alike. Federal judges in several states quickly issued nationwide injunctions, temporarily blocking the order's enforcement. But on June 27, 2025, the Supreme Court issued a pivotal ruling. The court did not rule directly on the constitutionality of the executive order. Instead, it sharply limited lower courts' ability to issue nationwide injunctions, allowing Trump's order to take effect in most states, while legal challenges continue. The ruling meant the order became enforceable in much of the country, though it remained blocked in states like Colorado, where local officials had joined lawsuits against the order. President Trump hailed the decision as a monumental victory for the Constitution, the separation of powers, and the rule of law. He emphasized that it would allow his administration to move forward with sweeping changes to immigration and citizenship policy. The impact of this new policy has been uneven across the country. In states like Colorado, where state officials joined lawsuits against the order, birthright citizenship protections remain in place for now. In most other states, however, the new restrictions are in effect, creating uncertainty for immigrant families and mixed-status households. The order affects children born to undocumented immigrants, temporary visa holders, and even long-term residents who have not obtained green cards. Immigrant communities have reported increased fear and confusion, with some families unsure whether their U.S.-born children will be recognized as citizens or able to access basic benefits. Internationally, the United States now joins most of the world in restricting birthright citizenship. Only a handful of countries in the Americas, such as Canada and Mexico, continue to grant unconditional citizenship by birth. This shift moves the U.S. into alignment with European and Asian nations that require at least one parent to be a citizen or permanent resident for a child to receive citizenship at birth. The chronology of these changes is striking. On January 20th, 2025, President Trump signed the executive order ending birthright citizenship for most children of non-citizens. The order took effect 30 days later, on February 19th, 2025, changing the rules for all births from that day forward. Over the following months, federal courts issued injunctions, and civil rights groups, along with more than 20 states, sued to block the policy. Then, on June 27, 2025, the Supreme Court's decision allowed the order to move forward in most of the country, while legal battles continued in a handful of states. The legal battle is far from over. Immigrant rights advocates have shifted to class action lawsuits, seeking to protect all families affected by the executive order. The Supreme Court's ruling means the issue could return to the High Court for a final decision on the 14th Amendment's meaning. Meanwhile, families across the United States are left in limbo. The order has already led to new policies in schools and hospitals, and some children may be at risk of statelessness if they are denied citizenship in both the U.S. and their parents' home countries. The confirmation of the end of birthright citizenship marks a dramatic turning point in American law. Driven by President Trump's executive order and enabled by the Supreme Court's recent decision, the United States has moved away from a tradition that once set it apart on the world stage. The debate is far from settled, and the consequences, for families, communities, and the nation's sense of identity, will unfold for years to come. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration News Channel. Thank you for watching, and we'll see you in the next video.
Has served as the backbone of family reunification in the United States. It allows U.S. citizens and lawful permanent residents to sponsor immediate family members, such as spouses, children, parents, and siblings, for permanent residency. While the process has always required documentation and background checks, it has historically operated under the assumption that keeping families together is a national priority. But that long-standing principle is now being reconsidered. Under new directives from the Trump administration, the Department of Homeland Security and U.S. Citizenship and Immigration Services are being instructed to treat all I-130 petitions with what officials describe as enhanced scrutiny, part of a broader shift in immigration enforcement philosophy. What's changing in 2025? The updated policy framework introduces a number of changes that collectively represent a major departure from previous norms. Revised I-130 forms now demand significantly more detailed personal and financial information from both the petitioner and the beneficiary.